Okay, well, good day, everybody, and thank you for being here. I'm John Dernbach, and I direct the Environmental Law and Sustainability Center at Widener Commonwealth Law School. This is the 13th year, believe it or not, of our Distinguished Environmental Speaker Series. We've made a point of inviting highly qualified speakers from a variety of backgrounds and perspectives. We've also made a point of giving our speakers the opportunity to reach beyond the academy and into the broader community, which is why we do this program late afternoon Eastern Time and on Zoom. Today's speaker is Elizabeth Kronk Warner. She is the Dean and Professor of Law at the S.J. Quinney College of Law at the University of Utah. She was formerly Associate Dean and Professor of Law at the University of Kansas School of Law, where she was also the Director of the Tribal Law and Government Center. Dean Kronk Warner is a nationally recognized expert in the intersection of environmental and Indian law. She has taught courses in property, Indian, environmental, and natural resources law, and supervised the Kansas Law School Tribal Judicial Support Clinic. She has received several Teaching Excellence Awards, co-authored several books on environmental and Native Americans, and has over 40 articles and book chapters to her credit. I should say that one of the book chapters is a chapter in a forthcoming book that I have co-edited, Governing for Sustainability, which will soon be published by the Environmental Law Institute. Dean Kronk Warner is a citizen of the Sault Ste. Marie Tribe of Chippewa Indians. She has served as an appellate judge for the tribe and as a district judge for the Prairie Band Potawatomi Tribe. She holds a JD from the University of Michigan and a BS from Cornell University. Her presentation today is Energy in Justice, a perspective from Indian country. Energy justice, or the lack of it, is a growing part of the national and even international debate about energy policy, who benefits and who is hurt by energy production. We know something about energy injustice in Pennsylvania because, for example, we have a long history of coal mining, which created wealth and powered the economy, but also left a costly legacy of polluted water and deeply scarred land. Two housekeeping items before we begin. First, if you want CLE credit for this program, please see the link to the evaluation form that will be put in the chat feature. You have to fill out the evaluation to get credit. Second, there will be time for questions at the end of the presentation. We've designed it that way. If you have questions, please put them in the chat, or if you prefer, you can ask it directly when the presentation is over. So I'll turn it over now to Dean Kronk Warner. Thank you for being here.
Great. Thank you so much, John, for that lovely introduction. It is truly an honor to be here. As was mentioned, my name is Elizabeth Kronk Warner, and my pronouns are she and hers. I come to you today from the Salt Lake Valley, and as I like to do before I start any presentation, I do want to acknowledge that we here at the University of Utah acknowledge this land, which is named for the Ute tribe, is the traditional ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples in their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. So how lovely today to have this wonderful outreach for me, activity to have this great opportunity to talk to you. And I appreciate the chance to be with you here today. So as John mentioned, energy justice is a big issue. It's an emerging field in the law, and really looking at these questions of where is energy development happening, who's being impacted, and how is it being developed. And so we're going to really look at this through kind of a case study lens, if you will, looking specifically at Indian country and how energy justice intersects with Indian country. But many of the principles that we're going to talk about could be applicable to lower socioeconomic or racialized communities in Pennsylvania, as John mentioned. So even though we're going to kind of focus on Indian country, I think a lot of this will have broader implications as well. Now, you'll note that the title of the presentation is A Perspective from Indian Country. Just a quick note on that. I use that term both colloquially and as a legal term of art. So in terms of a legal term of art, Section 18 USC 1151 defines Indian country as being three aspects. So it includes reservation land, so Indian reservations. It also includes allotments. So you may have heard that Indian lands were allotted in the late 19th, early 20th centuries. And so those allotments may be very far away from the actual reservation where the tribe now resides. And then also dependent Indian communities. And dependent Indian communities are communities where the federal government has set aside land specifically for the use and benefit of tribes. So I just wanted to point out how I'm using that term throughout the presentation, and that it does have a legal meaning as well. So what are we going to cover today? There we go. Okay, so first I want to expand on John's quick introduction to energy justice and how we're going to talk about it today. Then we'll do an introduction to Indian law, presuming that many of you have not had deep experience in Indian country, which is great because we'll have an opportunity to hopefully chat about something that's new. And then we'll talk about this intersection of energy justice with Indian country, starting with an overview, but then moving to obstacles to renewable or clean energy development in Indian country and opportunities that may exist in the changing landscape. And then we'll also talk about the development of more traditional forms of energy and how that may be impacting Indian country by specifically looking at one community, which is the Dakota Access community. All right, so next, let's start off by talking about what is energy justice. So as was mentioned, it's a relatively new field. Energy law, of course, has grown rapidly in the past 3 decades as a specialization within environmental law and natural resources law. Dozens of law schools within the United States now offer a broad amount of courses and have developed programs in the energy area, a trend that we only expect to increase moving forward. This is certainly in no small part due to renewed global focus on the need to address both the fossil fuel use that contributes to climate change and the modernization of existing aging energy infrastructure. So since 2016, 173 countries have ratified the Paris Agreement and made commitments to transition away from fossil fuels. Also starting in 2016, the electricity sector edged ahead of the fossil fuel supply sector to become the largest recipient of global energy investment for the first time ever. Global investment in renewable-based power was the largest area of electricity spending. In the technology and policy arenas, there is now tremendous momentum towards building smarter and cleaner energy infrastructure. It is within this context of climate change and historic energy infrastructure investment that energy justice broadly calls for a moral examination of energy systems from an energy law perspective. Despite the increased attention being given to energy law, the clean energy transition and grid modernization, however, the concept of this energy justice is relatively new. Although the concept has existed in practice for almost a decade, it was not really until 2013 that the concept began to fully develop within the academic sphere. Accordingly, the concept of energy justice remains under-theorized, and perhaps more importantly, few have considered how theories of energy justice might be applied practically. So we're really kind of in an interesting area of the law here. Energy justice seeks to refine and expand our legal understanding of how we plan for, invest in, and regulate energy to be beneficial for international governance, nations, and societies. Energy justice examines and promotes a global energy system that is safe, reliable, fair, reasonable, and also sustainable for current and future generations and the natural world. Importantly, it also considers the need for an energy path forward that is restorative or minimizes and reverses the cumulative impacts of the energy system. The need for restoration is critical as energy justice, above all, seeks outcomes. An energy justice perspective is also helpful when considering responses to the negative impacts of climate change. Climate change, once seen as a problem of the future, is here now. This necessity means exploring energy theory and practice that can address the needs and priorities of those now experiencing the negative impacts of climate change with the most intensity. Now, in Indian country, many of our communities are particularly vulnerable to the impacts of climate change, because unlike other communities where if you're not comfortable with what's happening in the environment, you could certainly move, or theoretically you could move. Many Native communities are specifically tied to an area of land, either because they're legally tied to that land, they have rights and responsibilities that are connected to a specified portion, such as a reservation existent or usufructuary rights, the right to hunt and fish. And many tribal communities have historical and cultural connections to specific pieces of land. They might have spiritual connections as well. So many of our tribal communities in the United States are uniquely kind of vulnerable to the impacts of climate change because they don't have the capacity for movement that other communities may have. There's a recognition that in developing energy transition strategies, a pure economic focus or even a pure greenhouse gas mitigation focus cannot yield results. Because certainly if we looked purely at economics and we were talking about relocation, that would be really hard to justify some of the communities that we're going to talk about today. It is important to note that the underpinnings of energy justice theory are still in development. To date, there are two main definitions of energy justice that have emerged. Both build upon justice theories that in energy advocacy have traditional roots in environmental justice and climate change. So the first definition advances the idea that energy justice is composed of three central tenets, namely distributional, procedural, and recognition justice. In the energy space, both distribution and procedural justice are closely identified with environmental justice. Distribution justice examines the allocation of the harms, benefits, and responsibilities of the energy system across society. Procedural justice calls for processes that meaningfully and fairly engage stakeholders in a non-discriminatory way. Recognition justice, then, while closely linked to procedural justice, seeks fair representation, including the right to be respectfully recognized with equal political rights. The second definition that has emerged advances that energy justice includes 8 core principles. And these include, as you can see on the slide, availability, sustainability, affordability, due process, transparency and accountability, intra-generational equity, and intergenerational equity and responsibility. These principles expand upon the first definition that I mentioned in that they address the temporal justice issues raised by climate justice theory. There are, of course, intersections between energy justice where it meets environmental justice, human rights, climate justice, and Indigenous rights. And of course, we'll be exploring those intersections today. Related closely to these intersections is the idea of involuntary resettlement, energy pollution, and energy poverty are key energy problems that need to be addressed and that the field will continue to look at. So there's certainly a robust area of conversation and many things that we could be talking about today, but unfortunately we'll only have time to specifically look at how these issues come up in Indian country. So now with that understanding of energy law, kind of where it currently is and where it may be going, let's also give a brief introduction to Indian law. Again, presuming that many of you had not had the opportunity to do much work in Indian law, I thought it would be helpful to have a quick primer. So first, I always get asked why I use the terms that I do, and in particular, people have a tendency to ask about this term Indian. So I use the term Indian for 2 reasons. The first, if you looked at the US Code, you know that Chapter 25 is the Indian Code, and specifically that federal Indian law uses their term Indian. Now, of course, I acknowledge and note that's not historically accurate. It's based on some uncertainties, but that is the term that is used in federal Indian law. Additionally, as John mentioned in my introduction, I am a citizen of the Sault Ste. Marie Tribe of Chippewa Indians, and so my particular tribe has decided to use that term Indians. And so I'm respectful of that. That being said, if you ever find yourself working in Indian country or working with a tribe, I strongly encourage you best practice is to use a person's specific tribal affiliation if you can. So for example, you now know that I'm a citizen of the Sault Ste. Marie Tribe of Chippewa Indians. So you would say, this is Elizabeth, she's Chippewa. Or if you were working with somebody who was Navajo, you would say, this is so-and-so and they're Navajo. Native American and American Indian are of course perfectly acceptable terms. These of course are used when you're tending to refer to a large group of individual natives or Indians. I in particular don't like the term Native American because I think anybody born in the Americas is a Native American, but that's just a preference. So that's a little bit of an insight. You're going to hear me mostly use the term Indian when I'm referring to Indigenous folks from the continental United States. If I'm trying to be more inclusive than that, you might hear me use the term Native or Indigenous, because we do have Indigenous groups in the United States that do not have federal recognition with the federal government. The classic example, of course, are Native Hawaiians in Hawaii, who are not recognized by the federal government, even though I think there's broad agreement that they are in fact an Indigenous groups, and there is many historical reasons for why they do not have recognition. So if I'm trying to be more inclusive of groups that do not have a federal relationship with the federal government, you might hear me use that term Native or Indigenous. Next, also be aware of the fact that Indian has both a racial and a political component. So I'm Indian both because my grandparents, my grandfather and my grandmother, were Native, and because I'm a citizen of my tribe. So if I were there with you, I could show you my tribal identity, my ID card. So my tribe has recognized me as a citizen, and I have a political relationship with that organization. So I'm Indian both because I have a racial history and because I have this political identity. And just as an aside, kind of interesting aside, tribes are kind of all over the map in terms of what they require for that racial component. Some tribes require folks to be 50% Native. Some tribes require mere ancestry, so that you can show that one of your ancestors had been a member of the tribe at some point. So, and that's part of tribal sovereignty. Tribes have the right to determine their membership. And so you will see that different tribes have different requirements. So for example, my tribe has a requirement that you have to be 1/4 racially Native in order to have political standing. So it's an interesting relationship there. What's an Indian tribe? You've heard that term quite a bit. So an Indian tribe, I use that as a political unit that is capable of legislating and regulating. Now, tribes have the strongest authority over their own members within their own territory. And they tend to have the strongest authority in areas of family law, probate, those really touching and concerning their tribal citizens and their tribal members. Tribes can, interestingly, since we're kind of talking in the environmental context, tribes can have authority over non-Indians on the reservation if one of two things is true. Either the non-Indian has consented to the jurisdiction of the tribe, or if the activities of the non-Indian have the ability to threaten the health, safety, or welfare of the tribe. And so interestingly, that second exception comes up not uncommonly in the environmental arena, where you might have a non-Indian whose activities are negatively impacting the reservation environment because of environmental pollution. And so tribes have been able to successfully regulate and adjudicate matters involving non-Indians in some environmental pollution cases, kind of as an interesting aside. As I mentioned and alluded to earlier, we have kind of three classifications, if you will, of tribes or political organizations within the United States. We have those that have federal recognition, and there are over 570 federally recognized tribes within the United States. And yes, there are some still on the East Coast in your area. And then we also have some tribes that don't have federal recognition, meaning that they don't have a federal relationship with the government, but they do have state recognition. So the state has said, we recognize that this is a tribe, that this is a political organization. And then last, as I mentioned earlier, we do have large indigenous groups, the Native Hawaiians being the most commonly used example, where those folks are clearly an indigenous organization, but do not have a relationship with the federal government or the state government for historical reasons. And this question of who is an Indian tribe is kind of an interesting intellectual one, because it's this question of external validity, right? Is the federal government or the state giving recognition versus internal validity for the community itself? And I want to acknowledge that for this presentation, I'm really looking at that external validity of, and mostly looking at whether or not the federal government has acknowledged a group as a tribe, but there's certainly internal questions as well. So what is tribal sovereignty? And again, kind of an acknowledgement there. I'm just talking about this from a legal perspective. There are certainly other elements of sovereignty, like cultural sovereignty. Food sovereignty has become a really hot topic lately. I'm really talking about this from the legal perspective. So as was mentioned before, a tribe is a governmental unit. Tribes predated the formation of the United States. So a common misconception is tribes have inherent sovereign authority. It is not delegated authority from the federal government. Oftentimes folks who haven't had a lot of opportunity to work with tribes think that tribes operate under delegated authority from the federal government, but that is not true. And that's because tribes pre-existed the formation of the United States. It's an interesting exercise. If you want to go and read the Constitution in your abundance of free time, you will see that the Constitution only refers to tribes in instances of Congress having the ability to regulate commerce with tribes, and then in terms of the president being able to enter into treaties with tribes. And that's really a recognition that the founding fathers did not see tribes as falling under their jurisdiction because they were separate sovereigns at the time. The law is different in Indian country. So for example, I always like to tell students, and it shocks them a little bit, the US Constitution does not apply in Indian country. Now, interestingly, many of the protections of the Constitution have been applied to Indian country through subsequent congressional statutes, but there are some exceptions. So for example, when you're in Indian country, there is no separation of church and state. And that's because some tribes have theocracies still in the United States today. Also, interestingly, if you're in Indian country, you have no right to representation. So again, there are some differences there. And tribes, as I mentioned before, have the right to enact laws to impact their citizens. And of course, as was mentioned before, there are other forms of sovereignty. All right, let's just talk briefly about the history of federal Indian law, just so we can kind of contextualize where we are. So of course, there was pre-colonial era. So under Great Britain, the policy was, and this really was consistent with the colonial era as well, was keep everybody separate. Right, the Great Proclamation of 1793, let's keep those folks, and that originally originated with Great Britain. Let's keep everybody west of the line, all the natives west of the line, and let's keep the settler colonists east of the line, and then we will have peace and harmony. So largely the colonial and the pre-colonial policy was to keep folks separated. And that was pretty much the same through even in the beginning of the United States. And it started to change in the early 19th century with some cases that we call the Marshall Trilogy of cases in Indian law. They're called that because Chief Justice Marshall played the critical role in each of these decisions. And you probably have read these because the Johnson v. McIntosh case is the first case that most property books have in at the start of the property case book. But this was the case where you'll recall that Chief Justice Marshall found that the actual land that tribes was on was not owned by tribes, that the federal government had secured that land through the doctrine of discovery by virtue of standing in the place of Great Britain, but that the tribes had the right of use and benefit of the land. And that remains true today. The federal government holds in trust for many tribes lands that the tribes then have the right to use and benefit, which becomes really quite interesting when you start to get into energy production and energy development, because it's part of the reason why the federal government plays such a big role in energy development in general in Indian country, because it is the federal government that is the actual landholder. And so some folks find that quite frustrating, that rather than the public market where the federal government may or may not have as big of a role depending upon where the development is occurring. In Indian country, you're always going to have to deal with the federal government because of that land ownership. The additional two Marshall Trilogy cases, we had the Cherokee Nation versus Georgia case and the Worcester versus Georgia case. I won't get into the details of those cases other than to say in the Cherokee Nation case, it's important because the Supreme Court found that tribes were domestic dependent nations. So it affirmed that tribes have sovereignty, and the Supreme Court has affirmed that even to this day, most recently in the McGirt decision. So tribal sovereignty persists today. And then in the Worcester case, interestingly, we don't see a large state interest in Indian country. So oftentimes you're dealing with the federal government and not the state. And that's because of that Worcester decision where the Supreme Court held that the laws of the state of Georgia had no force and effect within Indian country, basically because the federal government had occupied the field. So if you find yourself doing energy development in Indian country, you're not going to do a lot of work with the state. So it's going to differ somewhat from your other types of work. Excuse me. That was the early 19th century. As you know, President Jackson came into power and ushered in the removal period of history where tribes were removed from the East Coast and moved to the West, largely to the Oklahoma Territory. This was also the time when the federal government engaged in assimilation policies. The ideas you may have heard from Colonel Pratt, famous from a Pennsylvania connection because of Carlisle's where he started, but his idea, he was the one who said you kill the Indian to save the person or to save the man. And this was the boarding school reference, and you may have seen this as making the news, but the idea was to take Indian children, put them into a boarding school, have them lose their Indian identity, their language, their culture, and the idea of assimilating Indians into American culture. This allotment and assimilation policies were an abysmal failure. They were highly unsuccessful. And what happened is tribal identity persisted, but tribes merely got poorer. So it was a failure. And in the 1930s, the government recognized that. And you saw kind of a reemergence of tribal sovereignty under the Indian Reorganization Act, which explicitly recognized the tribal sovereignty of tribes and the ability of tribes to adopt constitutions. So many tribes now today have constitutions, which of course, if you're doing work, especially energy development work, you'll want to go ahead and look at that tribal constitution to look at the rights and responsibilities specific to that tribe. Then we entered into kind of really interesting historical period, juicy because the federal government started terminating relationships with tribes, the political relationship with tribes. And what's underlying this was actually very much in time with the McCarthy era. And many folks felt like having reservations, having these communistic plural societies was un-American. And there were concerns that Indians living on these reservations were not having the same access to benefits and rights that many Americans were. And so therefore there was a desire to terminate the political relationship and terminate the reservations. And so over 100 tribes did have their relationships terminated. Again, abysmal failure. It didn't result in assimilation. It merely resulted in poor communities becoming poorer. And so ushering in with President Nixon, interestingly enough, kind of another interesting historical piece of fact, President Nixon was the one who first called for tribal self-determination in his 1968 message to Congress. And that is the era that we currently find ourselves in, where the federal government acknowledges tribal sovereignty and the right to self-determination. And so again, even though the federal government has a large role and will have a role in energy development in Indian country, a lot of the applicable statutes call for the tribes to be involved in that type of development. So that's just a brief, again, we could spend a lot of time talking about each of those historical periods, but just a brief kind of overview to where we've been and where we currently are. Another thing that's important to be aware of when you're talking about Indian law is that there is this tension there. And in fact, Justice Clarence Thomas acknowledged this in a concurrence in Laura, because you have tribal sovereignty, and it is absolutely true that even modern day Supreme Courts have acknowledged tribal sovereignty, but yet at the same time, the conflict exists because Congress has plenary authority. That goes back to the termination era, right? So Congress has the ability, because it's kind of occupied the field and has this responsibility to tribes to do whatever it wants. So tomorrow, if Congress wanted to, tomorrow could upset and end tribal sovereignty. And if you want to read an interesting read, Justice Thomas's concurrence, because he said these things seem like they should not be able to exist together, but they do. And the fact that Congress has this ability and this control and this plenary authority has led to a federal trust relationship. And the Supreme Court has said that at the very least, the federal government always has a moral obligation to act in the best interest of tribes. But sometimes, and very relevant to our discussion of energy development, that becomes a binding legal obligation. If the federal government has affirmatively said that it will do something. So in the energy context, this oftentimes comes up where the federal government is managing land for the benefit of the tribe. So if the federal government has taken on this affirmative duty, then the US Supreme Court has said as recently as 2011 that the federal government has a duty to act in the best interests of the tribe. So as a result, the federal government, if it's not going to do something that the tribe has requested, has a duty to explain its reasoning, and potentially has a binding duty to act in the interest of the tribe, depending on the particular interest at stake. This has also led to a duty for consultation. So again, if you're engaged in energy development in Indian country, there's a very high likelihood that you are going to be required to undergo consultation with the tribes that are specifically impacted. And we'll see a little bit later in our case study about how that can and has had negative implications for energy developers in the past. All right, here's just a couple of, I'm assuming we can make these slides available to anybody who's interested. So if you wanted to learn more about Indian law, here's some great resources that you can use. And of course, I'm always a resource to you, elizabeth.warner at law.utah.edu. So you can have this. And then, but continuing on, getting specifically now with our background on energy justice and our background on Indian law, we can really start to dig into how these things are linking and impacting each other. And I do want to start off by acknowledging that there's a lot of overlap happening here in the energy justice field. We're talking in terms of climate change, the negative impacts of what's happening in Indian country because of climate change. We're talking about many tribes do want to engage in even traditional energy development because, as I alluded to before, many tribal communities are very poor communities and are very much interested in economic development. To environmental justice concerns, right? How is environmental development disproportionately impacting these tribal communities? So I do want to acknowledge that there's a lot of overlap here between these concepts and how they apply in Indian country specifically. So let's talk a little bit about renewable energy development in Indian country. So as we highlighted when we talked about energy justice to begin with, we talked about the fact that a piece of energy justice is specifically what type of energy is being developed. And there's been a big push, certainly under the Biden administration currently, and also internationally under the UN sustainability goals. And I want to give a shout out to John. He is one of the co-editors of a massive project that you spent a lot of time on, pulling together some really great chapters on each one of those UN sustainability goals. So big kudos to him and the work that he's put in on that. But there's this push towards cleaner energy, both because it's sustainable and because traditional energy sources can be very hazardous to one's health. So for example, a good portion of the world's population still relies on actually burning coal in the home. So not even burning coal to develop electricity, but burning coal in the home. And that can have very deleterious effects on one's lungs and one's physical capacity. And so energy justice asks these questions about what about clean or renewable energy development? And that has been very slow in coming in Indian country. Even though, quite frankly, Indian country, for those of you who are looking for places to do development, it's a great place to be. There's tremendous solar and wind, in particular, resources available in Indian country. That's because, as you may know, in the continental United States, some of the largest places of wind is coming off of the Rocky Mountains, just as you go over the East Rockies. A lot of tribes are located in that place, and also a lot of tribes are located in the west, in the southwest, where there's large solar resources as well. So there's a lot of untapped clean and renewable energy capacity in Indian country. So why has this remained untapped? And I think that is a core energy justice question, right? We have this capacity for development. We have interest in development, right? Our current administration is certainly incentivizing it. Why isn't this happening? Well, so the first is, of course, the incentive structures. So because tribes are separate political bodies, and they're not private third companies, excuse me. Many of the incentives that are written into tax policies, whether federal or state, do not apply to tribes because they're a political entity and not a separate entity. So a lot of the efforts that have been undertaken to incentivize this type of development simply don't apply in Indian country. So even though there's great capacity there, there isn't the incentive to do the development. Similarly, a lot of these tribes are in places without locations without the necessary infrastructure. So a classic example is the Blackfeet Reservation, which has tremendous wind capacity. It's right off the East Rockies. It's if you've ever been to Glacier National Park, it's on the eastern side of Glacier National Park, tremendous wind energy potential. But it simply doesn't have the infrastructure, the energy infrastructure there to take that wind energy and to bring it to a major population. And the cost of installing the infrastructure has not been incentivized, so it's truly prohibitive. Then you have the timeliness issue, and this is why I wanted to delve a little bit into the history of Indian law and back to those early 19th century cases. Because Johnson v. McIntosh is still good law today, the federal government oftentimes still owns this land. And so unlike dealing with private landowners where you have certainly a process, but it can be somewhat of a quicker process, you're dealing with the federal government at almost every intersection. And so as a result, things get dramatically slowed down in Indian country. And not only are you dealing with the federal government, but you're dealing with layers of regulations that are specific to Indian country. And so that just slows down the energy development. So if you have two potential sites in relative close proximity and one's on a reservation and one's not, the timeliness may make a lot more sense to go with the non-tribal community and to do development there. So these are just some of the reasons for why we haven't seen a lot of renewable development in Indian country. But that, of course, is changing. There has been some changes, some changes in that particular area. So tribes are trying to invest in clean energy. Some are doing it through pilot projects. So Standing Rock Sioux is a great example of that, where they were able to secure some seed funding from the Department of Energy in order to install local energy power sources so that they could supply clean energy to their community. That proved to be hugely successful. Similarly, the Winnebago tribe has obtained funding to install solar panels. And then interestingly, the Navajo Nation is actively engaged in solar energy development, not only to support the community, but is also looking to provide clean and renewable energy to outside entities. Fascinating enough, here at the University of Utah, we're looking to build a new medical campus, which of course will have a large energy footprint because a lot of energy is necessary to have an effectively running medical campus. And we're talking to the Navajo Nation about the possibility of a power purchase agreement in order to obtain that through these solar energy developments that the Navajo Nation is engaged in. So there is some change. But it's slow. It's not as fast as we're seeing in other areas of the country for the reasons that I articulated earlier. So we can really ask whether this is a community that is being left out of renewable and clean energy development and whether that's fair, which is fundamentally, of course, an environmental justice question. Next, I want to give kind of a case study for if we're talking about energy infrastructure, and that's the Dakota Access Pipeline. And you may recall that this was a case that really made the news quite a bit in 2016 and 2017. You may recall that thousands of Indigenous folks from around the world, as far away as New Zealand, came to the Standing Rock Reservation in order to protest, what was at issue was a permit to link the Dakota Access Pipeline underneath a lake. And that's why the Army Corps of Engineers was involved, because they're the entity, the federal government entity that approves that linkage underneath waters of the United States. And so there was protest. Now, interestingly, we'll talk a little bit about the background of this claim and some of the legal claims that came up. But I think it's a nice example of these justice claims that tribal communities are raising around energy infrastructure, and especially around pipelines. Tribes have been successful in challenging several pipelines around the country. And also, interestingly, in the Pacific Northwest, you may have seen that there were several proposals for terminals to bring in coal from foreign governments, and tribes have successfully used their treaty rights in order to prohibit the construction or significantly slow down those terminals. So tribes are having a big impact on energy infrastructure around the country. So let's kind of look at this particular case and energy justice and how it unravels here. So again, these are just some pictures to give you a sense of the scope. I really love the picture to the left of your screen. Every tribe who came, or representatives from tribes who came, would plant their tribal flag when they got there. And so I think it's a nice representation of just how many tribes and tribal individuals were there. So I think it's important to acknowledge the historical context of the controversy, because sometimes folks say, well, why did that become such a big deal in Indian country? And this Standing Rock Sioux case is a great example, because this is the same community where the federal government abrogated its treaties. This is where gold was found. You may recall that this is where the Battle of Little Bighorn occurred. When the Sioux refused to give up their lands, this is where the federal government overhunted buffalo in the effort to starve them into capitulation. In 1890, the federal government outlawed Indian religions, and this is where you saw the 7th Cavalry murder approximately 200 people who were engaged in a ghost dance ceremony. Even 50 years ago, the federal government seized a lot of these lands in order to build a hydroelectric dam. And as a result, kind of the cumulative impact of all of this is that this is a community where they lived in some of the poorest counties within the United States. So this is certainly a community, it's not just about the permit, it's not just about the pipeline, it's kind of this historical trauma that the community has experienced. And so again, we have to really ask if there's justice here. The permits at issue, there were 2 permits. There's both the nationwide permit, as you may be aware, there are regional nationwide permits that are approved, and the tribe did not engage much in the nationwide permitting, which happened in 2012. And that's just quite frankly, because if I recall correctly, it was several states that were applicable to that nationwide permit. It was not clear that a pipeline would potentially impact the tribe, and the tribe was not in a position to be able to engage in consultation on that nationwide permit. And so that's, again, another reason why we see all of this focus on the Army Corps of Engineers permit issue, specifically connecting the pipeline. So that's the issue that we'll focus in on. What was the pipeline? So the company, knowing that, of course, it can be more timely and expensive to negotiate with the federal government, largely constructed the pipeline on private lands. It's almost a $4 billion energy infrastructure. It would allow for oil in North Dakota to reach refineries in the Gulf Coast, or it does. It's currently in operations. Now, part of the justice question asked, though, originally this pipeline was slated to go just north of Bismarck. And Bismarck is a largely non-diverse population, largely European ancestry, and for reasons that folks have challenged and certainly had discussions about, that path was moved from just outside of Bismarck to a half-mile north of the tribal community. So again, not on federal lands, right? Not on the tribal lands, because that would take more time, but just over the border. And the tribe and tribal citizens were very, very concerned about what would happen to them and to their environment if there were, in fact, a pipe leak. So several justice concerns here. Concern that the pipeline was moved from Bismarck, which again was a non-diverse community, to the tribal community, which is largely diverse. Community impacts, concerns about cumulative impacts, not just on the water itself, because obviously this pipeline's underneath a lake. The lake is very important to the tribal community, but also how a leak would impact the tribal community is very much reliant on fish from the lake and also on wildlife that rely on the lake. So what would be the cumulative impact to the community? And then of course, real concern about lack of effective consultation. The tribe said, you know, you didn't treat us like a separate sovereign and really engage on a sovereign to sovereign basis. And the federal government said, well, yes, we did. So there was disagreement on the consultation. So ultimately, what happens here is under the Obama administration, this is happening at the very end days of the Obama administration, the Secretary of the Army says, okay, we're going to take this back, look at these justice concerns, and engage in effective consultations. But of course, we had a new presidential administration that comes in 2017. The Tuesday after President Trump is sworn in as president, he issued a memorandum to the Secretary of the Army saying that this should go through expedited review and be approved as soon as can be consistent with available laws. So the postscript is that the pipeline did start to go into operation starting in June of 2017, but that of course did not end the legal challenges. So the tribe, as was mentioned on the earlier slide, tried several challenges. And interestingly enough, it was the justice challenge that at least at the district court level kind of won the day. They specifically brought an environmental justice, so not an energy justice, but remember the two are very closely related, an environmental justice claim arguing that the federal government had failed to consider those impacts on the tribal community and that the federal government has a duty to do so under various executive orders. And so the tribe argued that the federal government had failed to meet that duty and that was arbitrary and capricious behavior under the APA, the Administrative Procedures Act. And the district court bought it. So it's kind of an example of where these justice concerns, oftentimes folks think about these as morality questions, but we're seeing from the Dakota Access Pipeline that they're coming to be more than that they're coming to be legitimate legal arguments as well. And certainly for folks engaged in whether it's energy development itself or energy infrastructure, really need to be thoughtful about these questions of energy justice and how they come up. So that's my presentation, Che Miigwech, and I am happy to answer questions.
Well, that was quite wonderful. Thank you so much. We have, I'm not seeing any questions in the chat. And so I think I'm going to open this up. And does anybody have any questions? At all? I'm not seeing you, let me know, but I'm not seeing anybody.
Oh, looks like there's one. Alex says I have a question. I can't unmute.
Okay, yeah, Jackie Hand's got a question.
Yes.
Jackie, can you unmute?
There. Now, can you hear me?
Yes. Hi, Jackie.
Hi, how are you?
Good. How are you doing?
Presentation.
Oh, thank you.
Bringing together a very complex idea in a clear way. I'm wondering if you have any thoughts about the Enbridge 5 pipeline and how that fits into all this. And I'll admit I have an ulterior motive. I'm doing a lecture for somebody else's environmental class in 10 days, and I'd really love to have your thoughts.
Well, great. Always happy to chat with you. So Jackie is a beloved environmental law colleague in Michigan. So I'm not at all surprised that you're asking about Enbridge 5. So Enbridge 5 is a pipeline controversy happening in Michigan. And Jackie, I assume you're asking about the controversy specific to the Mackinac Straits pipeline? Yeah, because there's also some controversy in Wisconsin about a different pipeline. So Enbridge is fighting battles on all different sides right now in the Great Lakes region. So this particular controversy involves a pipeline under the Mackinac Straits. So of course, this place between lower Michigan, lower peninsula and the upper peninsula of Michigan. And what's at issue is you have this really old pipeline that is quite decrepit. And so there's concerns that the pipeline, at any time could cease to be functional. But also another concern about the pipeline is, my understanding is that it's impossible. The Straits of Mackinac are a common transportation corridor with many freighter ships that come through. And so there's some concern that these freighter ships, it's impossible for them to know where the pipelines are at the bottom of the straits. And so at any time, it would be possible for a freighter to drop anchor and actually sever one of these pipelines. And several of the tribes in Michigan have vigorously opposed this because, as you might imagine, in Michigan, given the Great Lakes region, fishing treaties are very important. And in fact, the tribes have an extensive fishing treaty with the state of Michigan. It's called the Cora Agreements. And the tribes are arguing very similarly to the Dakota Access argument that there are real justice concerns here, because if the pipeline were to rupture for any reason, that could have tremendous impact on their fisheries, which many of them rely upon, and they have this treaty. And I think the answer to your question is very much going to turn, Jackie, on this election and what happens in the election, because the state of Michigan has very much gone back and forth of whether or not it has supported the tribe's claims. And so the tribe hasn't pushed forward on the legal claims in court when the politics of Michigan have been supportive of their claim and not supportive of Enbridge. So I think your midterm elections are going to be really important, Jackie, that you get to vote on here in 2 weeks? Next week? 2 weeks, lost track of time. And I think that'll turn. But the reality is, if we want to look at the strength of tribal treaty rights, I think that if tribes litigated, they would be in really good standing. Tribal treaty rights is the one area where tribes have been very successful. And as I mentioned before, tribes have used their treaty rights to successfully block other energy infrastructure development, such as the terminals in the Pacific Northwest. So it's the one area, and they have a very good friend in Justice Neil Gorsuch, for example, on the US Supreme Court. So given that they're rooting their claims in the treaty language, I think the tribes have, if they do end up going to litigation, have a real chance of success there. So Enbridge is finding itself in a really kind of difficult PR and legal position. And that's a classic example where if we had more time, I would talk about the importance of effective consultation. And in fact, this has become such an issue that in Canada, the government has allowed for private companies, and they're largely energy companies, to do what are called IBAs, individual agreements, with they call the tribes First Nations. So because the companies kind of want to take ownership of this, because they don't want their energy project to get mired in litigation, and they want to do the consultation with the tribes directly. So it's kind of an interesting, just the neighbors to the north, Jackie, how they're engaging and how private companies are now trying to take over these consultations to avoid this type of quagmire.
So I'm not looking at whether other people have their hands up, but there's a bunch of questions in the chat.
Yeah.
So I'll just start with them in the order in which I see them. Do reservations have their own environmental laws specific to their lands? Is that a priority?
Yes, they can. So that's specific to tribal law, and they have the authority to do so under their inherent sovereignty. The extent to which they have tribal law, tribal environmental law, differs based. Tribes are in very different situations in terms of resources across the country, in terms of whether or not they've been able to develop fully robust environmental laws. Also, the federal government has occupied the field in many instances. So for example, the Clean Water Act, the Clean Air Act, the Safe Drinking Water Act are all statutes of general applicability, meaning that the US Supreme Court has found that they apply in Indian country. So tribes cannot do anything to undermine or go against those laws. Although many, the three that I just mentioned, all have what's called tribes as states or TAS provisions, which allow for tribes to act very similarly to states in terms of cooperative federalism and establish environmental standards. So for example, under the Clean Water Act, tribes can determine the delegated uses of specific water bodies, and they're able to do that under their TAS status. So anywhere where the federal government has not occupied the field is valid and open. So a classic example is because the federal government has not adopted a nationwide clean or climate change policy, adaptation policy, many tribes are actively engaged in adaptation planning.
Okay, great. So another question, can you share any stories from tribes in the eastern US that have had energy development projects lately?
Yeah, a lot of tribes, again, they're all kind of doing the same thing. On the east, there's a lot of wind potential with the Winnipeg and the tribes that are in the Rhode Island area, coastal area, because as you may know, there's a lot of offshore wind potential. And so that's something that the tribes are very actively engaged in, Meshintucket Pequots, and looking at the potential there. They're running into the same obstacles that we're seeing that I mentioned.
All right. Another question, I think this is about the Dakota Access Pipeline. Is there a feasible third option, or is the goal to stop the movement of the Gulf from the oil from the north to the Gulf?
So the pipeline's operational. So in many ways, I think I share that story as an example of what not to, because it stalled down the pipeline. All parties were disappointed. And folks left feeling like, everybody left feeling disappointed in that process. I think what the tribe was really concerned about were those cumulative impacts, and the impacts to the water, and then the impacts on the wildlife that they relied upon. And so what I don't think you see in that Dakota Access was a real kind of robust engagement. And I think robust consultation is oftentimes the solution to a lot of these energy development challenges. Because if the tribe has the opportunity to say, here's our real concerns, and then, so for example, in Canada, you could use an IBA, and the corporation could say, well, here's how we'll mitigate it. You can find common ground. So tribe, I mean, some folks, I mean, every tribe is different, right? 570 plus tribes, each, you know, they're not a monolith. And so some tribes may be absolutely against pipelines no matter what. But oftentimes when I work in Indian country and talk to folks, it's not necessarily the energy development or infrastructure itself, it's the lack of consultation and the lack of any efforts to mitigate the cumulative impacts that the tribal community is concerned about. And I think that's what Standing Rock and then Cheyenne River Sioux was also involved in that litigation would say, is that there was just no effective consultation. Their concerns were just not taken into consideration.
Okay, great. So another questioner asks, you mentioned that the lack of access to tax credits has been an obstacle to clean energy development. The questioner says, I understand the recently enacted Inflation Reduction Act, now allows for direct payment of clean energy. Hang on a second here. I'm having trouble manipulating the chat. There we go. The recently enacted Inflation Reduction Act now allows direct payment of clean energy tax credits to tax-exempt entities. Does that resolve the issue? And if so, have you seen any signs of renewed interest in clean energy development as a result?
Yes, people are excited about this. It's still a little bit too early to tell, obviously, about whether or not it's truly going to have an impact, because you have the other barriers that we talked about as well. But yes, I've already seen panels and workshops organized to talk about exactly this type of thing. So stay tuned. It might, if some of the other issues of logistics and location and timeliness can be overcome, I think it could be a potential solution to a lot of those obstacles.
Okay. Still another question. There's actually a bunch of questions here. I think I've got 3 or 4 more. My inclination, by the way, I understand we're coming up at 5 o'clock. I understand some of you are time bound, but if it's okay with you, I'd like to just go to the end of the questions. So this is a question raising an environmental, who has standing to raise an environmental justice claim on behalf of a tribe, and what legal process is available within a tribe to decide if the injustice claim is satisfactorily resolved?
Right. So the tribe, and again, using the Dakota Access. So in that example, the tribes themselves were the claimants because they were the alleged injured party. And the way that environmental justice and certainly energy justice, because energy justice is even relatively newer than environmental justice. But as you know, several presidents have enacted various environmental justice executive orders, President Clinton, President Obama, and certainly President Biden has made environmental justice a key piece of his administration. But they're oftentimes in these executive orders, which in and of themselves have no binding force or effect, right? You get to the end of the executive order, it says, this creates no rights. This is just the president talking to his agencies. And so the way that the tribes have gotten around that is through either NEPA or the APA. So, and basically it's the same tactic. It's arguing that the federal agencies had this duty to consider environmental justice impacts, and they've under the executive orders, and they failed to do that. And so the way they operationalize that claim is through NEPA or the APA. So that's where we've seen that effect. Now, the issue of injustice claims is satisfactorily resolved. Now you're getting into a whole nother area of Indian law, which is really challenging. And not unique to tribes, because you certainly have this, in any time you're dealing with government, where the government may negotiate for something or may bring a claim and be happy with the settlement or be happy with the resolution. And you could have citizens who absolutely disagree with that. So how the justice claim is satisfactorily resolved will very much change based on the tribe. So for example, some tribes are highly decentralized, where chapters, for example, with the Navajo Nation, control a lot of the power, and some tribes are very centralized, where they have one strong central government. So it really depends on the tribe, and you're getting into a whole nother challenge. So for example, historically, there were a lot of critiques of the federal government because they didn't negotiate with the proper entity. But the question is, who is the proper entity? And we could do a whole ethics presentation on who is your client when dealing with a tribe. So you're definitely getting into an issue that is a thorny one.
So here's a question about the interplay between tribes and other stakeholders in the U.S. West with respect to water rights issues. Obviously, the questioner says there are substantial concerns about water in the Western U.S. Is that somehow controlled via the TAS principle that you articulated?
So when you talk about water, you're talking about two different issues. You're talking about water rights, which is the property interest, and then you're talking about water quality, which is the pollution control. So when I talked about the Clean Water Act and the TAS provisions, the Tribes of States provisions, that goes to water quality. And so certainly tribes have a role to play. If they have TAS status, then they can control the water quality. So the famous case there is City of Albuquerque versus Browner, where the Pueblo, which is south of Albuquerque, had much more restrictive water quality standards than the upstream city of Albuquerque. And that was because the water had spiritual and cultural importance to the tribe. And so the tribe put forward to have TAS status, was approved by the EPA. That's why it's Carol Browner is the named party. The EPA approved those water criteria standards. And then the tribe, through the EPA, moved to enforce those standards against the city of Albuquerque and said, well, you absolutely can't do this. And the court disagreed and said, yep, that was a reasonable interpretation. That was a reasonable action by the EPA in approving that. So for tribes who do have TAS status, they can potentially have a lot of power in terms of water quality. Now, the last time I looked at it, it's been a couple of years since I've gone and looked at the number of tribes who have TAS status under the Clean Water Act. It was relatively few. It was less than 100. So most tribes, because as with anything, it takes time and resources to be able to apply for that. And so the majority of tribes had not, at least as of a couple of years ago, not gotten TAS status. But the other piece of your question actually goes to the property interest in water rights, which is oftentimes, what we're fighting over in the West, right? It's Mark Twain's famous whiskey is for drinking, water's for fighting quote, is oftentimes over those water rights. And so tribes, interestingly, it's Winter's decision from the early 20th century held that there are reserved federal rights in reservations for tribes. So even though the reservations didn't specifically talk about water rights, that in order for tribes to be able to make a homeland in those areas, that they had to have reserved water rights. And many courts have found that those water rights have a prior appropriation time immemorial, which means that they're usually the first in line in terms of priority for water rights. So many tribes have relatively strong water rights claims in the West. The rub is, though, of course, it takes decades to adjudicate water rights. And so what we're starting to see is that many tribes are actually entering into settlements. They're kind of forgoing the opportunity to litigate and entering into settlements because the likelihood of effectively adjudicating those rights is really poor. And so super hot topic in the West right now, for example, is the Colorado, you may know that the Colorado River Compact is coming up, is expiring. And so how are we going to renegotiate these water rights? It's a hot topic.
So I'm seeing two more questions in the chat. Can you comment on the questioner has read an article that some tribes are concerned about the loss of revenue from fossil fuel development on their land because of Biden's policies. The questioner asks you to comment on that.
It's absolutely true. So tribes are not a monolith, and every tribe has a different perspective. The classic example is Northern Cheyenne and the Crow tribe, who are sister tribes. They're right next to each other in Montana. Northern Cheyenne has said, absolutely not. We are opposed to traditional fossil fuel development. The Crow tribe has said exactly the opposite. We're really excited about fossil fuel development, coal development, and so we want to engage in this. And so you saw Crow tribal leaders meeting with President Trump, and President Trump had a White House Native leaders, where the Native leaders who met were very concerned about these timeliness issues that we were talking about before. And so they were working with President Trump to speed up the timeline. And now, of course, we have a different administration, different philosophy. And so that's exactly true. You have some tribes who are very happy that we're moving away from traditional fossil fuel development. And you have some tribes who aren't. So it is absolutely one of these issues where there is disagreement in the community.
So last question, might be technical or not, I'll let you decide. Can you speak about SO 3403 and the recent efforts to enter into tribal co-management agreements for management of public lands and waters, and whether you think these are feasible in more contentious situations such as mining leases for critical raw material mining? And the example given is Thacker Pass. And the questioner says, I think you addressed this to some degree by saying something about sometimes robust consultation can lead to consensus on energy development.
Yeah, you got me. That's exactly what I was going to say. So actually, this is something I'm pretty excited about, co-management. I'm a big believer in effective consultation because I've seen it work. Like I mentioned before, the Rose Pipeline, for example, is a situation where the company worked directly with the tribe, and they were able to come to an agreement that allowed for the pipeline to move forward in a way that the tribe was really happy with. So it's not a situation where all tribes are against all types of energy development. It's a situation where oftentimes tribes feel like they don't have a place at the table. And I can give you example after example of Indigenous communities around the globe where that's true. And so I think I'm excited about the idea of co-management, because if you have that agreement in place, it can be really effective. And we've seen this both in terms of managing the resource and in terms of avoiding litigation, right? So if our ultimate goal of lawyers is to keep our clients out of court, then these types of agreements can be really effective. And we've had co-management agreements in place historically. So for example, the bison herd in Montana, water resources, we've had co-management, Bears Ears here in Utah, excuse me. which I know is controversial. So I think it can be an effective mechanism, if we're kind of thinking about ways to do development in a way that is just, at least as far as tribal communities, consultation and co-management can go a long way.
So that's the last of the questions from the chat, and we're out of time. And you've been generous with your time to go on with additional questions. They were just a couple of housekeeping items before we wrap up. There's information about CLE in the chat and getting credit for CLE in the chat. I also posted a note earlier that if you are interested in the PowerPoint slides, you can email Brian Fernbaugh for them, bmfernbaugh@widener.edu. You should be able to find that in the chat. We're also going to post this on our YouTube channel, and we'll send out a link on that. Not quite sure virtually how you can everybody can applaud together, but I would like to thank Dean Kronk Warner for an excellent presentation and for participating in our program. So thank you so very much.
Truly my pleasure. And you have my email address, just elizabeth.warner@law.utah.edu. And if you have any questions, feel free to reach out anytime. It's a pleasure to be with you and have a chance to talk about these issues that are so close to my heart.
Thank you so much.